Just about 10 days ago, a little bit less than 2 weeks ago, we had DOMA being struck down. Great news for America, progress being made. Now, at the time, I was one of the people saying, let's not get ahead of ourselves. This is not the slam dunk win for equal marriage rights that some people were making it out to be. If you actually read the rulings, they were pretty specific in what they were making clear they wanted this to be applied to in the future. So on the case of DOMA, you had the extension of federal tax benefits and other sorts of financial benefits to people who had gay marriages in various states. That was obviously a good thing, but they tried to make it clear in that case that they were not saying that states can't outlaw gay marriage. What's interesting is that despite the Supreme Court, in particular Kennedy, who wrote one of the opinions, his attempts to make it very constrained in what it could be applied to, already it's being applied to a number of different equal marriage equality trials that are being conducted right now. And so the particular line that's being quoted in many of these is when Kennedy said that the provision denying federal benefits to legally married same-sex couples in different states humiliates tens of thousands of children now being raised by same-sex couples. And again, he was trying to be very specific there, supposedly. I personally am starting to think that he just did it to convince the conservative justices on the court. And maybe he anticipated or hoped that it would be interpreted more widely. But that's what's happening right now. So John Davidson is the legal director for Lambda Legal. He says that one of the reasons that it can be used now to challenge some of the state-level bans on same-sex marriage is that it's stigmatizing and it's harmful to people, and particularly harmful to children, when the parents' relationship is treated as inferior by the government. Those points are points we'll be making in all of our marriage cases. And so this is not the first time, by the way, that this sort of fairly well-crafted and tailored language in a Supreme Court opinion will be used much more broadly. The same sort of thing happened in the wake of 2003's Lawrence versus Texas, and we actually have some interesting stats on that. So if you go back to 2003, 13 states at that time still had laws against sodomy when the court finally switched over and said that the states can't have laws that intrude on the private personal conduct of people based on their sexual orientation in that way. If you go back a little bit farther, go back to 1967, interracial marriage was still legal in 16 different states when finally the Supreme Court ruled on it. Go back again, 1954, when the court issued the Brown decision, getting rid of some of the state-sanctioned segregation. 17 states still had formally segregated school systems. And so what's interesting is that the Supreme Court they'll hear cases sort of on the periphery of these big civil rights issues. And that's typically how this happens. You have years or decades of these peripheral cases being ruled on, and then steadily the language used in the opinions accumulates and eventually is used in a landmark decision. And in all of these cases, the Supreme Court was fairly clear, implicitly or even explicitly, that they did not mean to make any sort of landmark decision until finally you have an accumulation, a gathering of momentum judicially, and eventually they do make that big decision. And so right now, it seems like the Supreme Court made the move that they're going to make when it comes to gay marriage, and so God knows when finally they'll make again, a Brown-level landmark decision. And so people are starting to speculate, now that this is being used, the language of Kennedy is being used in these other court cases, what will it take for that sort of tipping point? Some people believe that it'll take, we have here one of the civil rights fighters, Tushnet, says 40 states allowing it. And if you look back at the three different cases that we talked about of those landmark decisions finally being made, you had 13 states remaining being against civil rights or same-sex equality, 16 states, 17 states, so it might not even take that long. And now, look, right now we only have 13 states where same-sex marriage is legal, but the acceleration has been happening. And so in a decade or two, is it inconceivable that we could have 30 to 40 states? No, I don't think that it is at all. And sort of oddly enough, Kennedy's language that was used diplomatically to bring some of the conservative justices over to his side might be what is required when that tipping point is reached to have an actual federal allowance, a constitutionality ruling in the Supreme Court for gay marriage. Scalia is going to be pretty pissed when that happens.